Afternoon and welcome to the June 9th, 2022 hearing of the Seminole County, Florida Special Magistrate. Before we begin, I would like to advise everyone about the procedures that govern appearances before me. This meeting is open to the public under Florida's Government in the Sunshine Law. Therefore, every effort will be made to hear all persons having relevant evidence or agreement to offer. The ethics law of the state of Florida requires that the county keep track of every person who appears before an official hearing officer of the county, whether in an effort to influence the decision-making or to encourage the passage, defeat, or modification of any proposal or recommendation. In order to implement the state law, it is required that every person who appears before me be registered with the clerk to my left. The cases where the respondent are present and signed in will be heard first. You will be sworn in or affirmed by the clerk. Once all cases where the respondents are present have been heard, the special magistrate will return to hear the remaining cases as they appear on the agenda. When your case is called, please be seated at the table reserved for the respondents, which is right over here. In that the county has the burden of proving a violation exists, the county will present their case, and then the respondents will be allowed to present their case. Additionally, please limit your comments to only information relating to the case. Each party may question each other's witnesses offered on behalf of the other party. Additionally, staff members may question those appearing before me. I will then make my decision based upon the evidence and testimony presented by both parties. All proceedings before me are electronically recorded. Please speak directly into the microphone at the center of the table and state your name clearly before presenting your case. Should you need assistance due to a hearing impairment or a language barrier, please inform the clerk. Excuse me. To avoid interference with cases being presented, all cell phones and other electronic devices are to be turned off or silenced while inside the chambers. Thank you for your cooperation. The first case is going to be called after we swear everybody in.
Could you please stand and raise your right hand to be testifying? Do you swear or affirm the testimony you're about to give is the truth? Yes. Thank you.
Thank you. The first case is 2248 CESM, respondent Ms. Gloria Day. Good afternoon.
Hi. Thank you.
Kyle Kasich, Building Inspector. I have presented a copy of this presentation to the clerk and request it be entered into the record.
It's accepted. Thank you.
Case number 2248 CESM is for the property located at 2325 Audley Street, Oviedo, which is owned by Gloria Day. The violation charged is Seminole County Code, Chapter 40, Appendix A, Section 105.1. The description of the violation is installation of a fence, gate, and access control unit without the required permits. The case summary is as follows. The initial inspection was 12/13/21. The notice to respondent was 12/13/21. Compliance date was 1/27/22. Follow-up inspections as shown, both on-site visit and via computer. Results of the re-inspections, the violations remain on the property. This screenshot from the property appraiser's website shows Gloria Day is the record owner of the property. This is a copy of the received certified return receipt for notice of this hearing. This is a photograph of the violation taken 8/31/21. Another photograph of violations taken 8/31/21. This is a photograph of the access control panel taken 8/31/21. And these are aerial photographs taken 1/30/22. And more aerials from 2/12/22. This screenshot shows no permits issued to correct the violation. Permit application 20-5867 for a 5-foot wooden fence and metal entry gate, currently in PC status pending zoning corrections. An application has been received requesting to vacate an unnamed right-of-way. The petition to vacate is not yet approved due to an incomplete application. The workflow task requesting the missing document has been on the side of the applicant since 5/11/22. Review cannot be completed until all required documents have been received. This shows a copy of Chapter 40 in which they are in violation of. Recommendation, based on the testimony and evidence presented in case number 2248 CESM, it is determined that the respondent is the record owner of the property located at 2325 Audley Street, Oviedo in Seminole County, as determined by the property appraiser's records, in possession or control of the property, and in violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1. It is further recommended that the special magistrate order the respondent to correct the violations on or before August 12, 2022. In order to correct the violations, the respondent shall obtain the required permits for the cited violations. If the respondent does not comply with the order, a fine of $50 will be imposed for each day the violations continue or are repeated after compliance. The respondent must contact the inspector to verify compliance. This concludes my presentation.
Thank you. And just a couple of questions for the county. That permit application that was submitted on April 27th, 2020, if that permit was issued, would they be in compliance, or is that not the correct permit?
This would cover the wooden fence and metal entry gate, but they would need another for the access control unit.
Okay. And then my other question, with respect to the vacate application, is that necessary in order to get the fence permit approved? You need a vacate of the right-of-way? Is the fence in the right-of-way or something, or?
They would need to speak to planning development for that. I believe that is what the corrections are referring to.
Okay.
That
I
is
was just
needed
trying to
by zoning.
figure out the relevance of the vacate. It
Yes.
must be, well, we can ask the applicant too, but, okay, thank you. Does the respondent wish to respond?
Okay. I'm trying to, the question that you was asking him, I'm trying to vacate that little piece in there. That way I can put my two properties together, and then I can keep my fence. And that's in the process that I'm at right now. I don't know if I answered your question, but
You
I don't
did.
understand.
Thank you.
Yeah, I don't understand a lot of things. I'm trying to, and they're helping me. I appreciate that.
Okay.
And now I'm waiting for this application that I submit to be approved. And I don't know what else I need to do, if I need to apply for something else or any other permit.
It sounds like staff is saying that you do have another permit to apply for to be in compliance for the access control unit? Is that
Okay.
correct?
Correct. And then as far as the vacate for the unnamed right-of-way, you will need to go speak to planning and development. There is a correction that is there are, I apologize, further documents that are needed.
Okay.
Which it seems has been, task requesting the missing documents has been on the side of the applicant since 5/11/22. So you'll need to speak with planning and development to find out what further documents they need so they can actually process your request. At the moment, they don't have all of the documents needed, so they're unable to process that request.
Okay, what is the site? What that means? What is, how I know that happened?
You
I don't
might be
receive-
able to go up to the second floor at the desk and ask the questions, right? When you leave here, you could go right
Okay.
in.
Okay.
And they'd be able to help
You can
you.
give her the case number. at the top of the application. That's the case number.
Oh, and do you have this packet?
Yes.
Okay, so on the page that looks like the one on the screen, which is,
Yes, I got it.
you got it? If you show them that page and ask them what else you need, they'll be able to answer that for you.
And in there also, I applied for the other permit?
The other permit is downstairs here on the
Here,
first floor when
okay.
you first walk in, so you could go try to do both.
Yes.
Okay?
Okay.
So what we'll do is we'll find you in violation, but you'll have until August 12th to come into compliance.
Okay.
So if you have some issues between now and then and you have to ask for more time, you can come back and ask and explain what you've done between now and then and why you need more time. But for now, there won't be a fine imposed today, but after August 12th, if you're not in compliance, there may be.
I understand.
Okay, thank you. Have a good day.
You too.
Okay, the next case is 2253 CESM, respondent Ms. Borman.
Here's the extra copies that she made. Can we give that to Kim?
Good afternoon.
It's title, insurance documents, and survey.
Okay, we'll have the county go first, and then we'll give you a chance to respond.
Okay.
Kyle Kasich, Building Inspector. I have presented a copy of this presentation to the clerk and request it be entered into the record.
It's accepted, thank you.
Case number 2253 CESM is for the property located at 805 Francis Street, Altamont Springs, which is owned by Melissa L. Borman. The violation charged is Seminole County Code, Chapter 40, Appendix A, Section 105.1. Description of the violation is privacy fence installed without the required permit. Case summary is as follows. The initial inspection was 4/14/18. Notice to respondent was on 4/14/18. Compliance date was 4/30/18. Follow-up inspections as shown, both on-site visit and via computer. Results of re-inspections, the violation remains on property. This screenshot from the property appraiser's website shows Melissa L. Borman is the record owner of the property. This is a copy of the received certified return receipt for notice of this hearing.
Yes.
This is a photograph of the violation taken 4/11/18. Another taken 11/19/21. Another 2/11/22. And finally, another 3/7/22. And finally, 6/8/22.
I haven't received all of those.
The screen shows no permits applied for or issued to correct the violation. Permit application 18-7440 received on 4/25/18. However, it was subsequently voided due to inactivity for 180 days. Permit sent back to corrections for required setbacks on 4/26/18. This shows a copy of Chapter 40 in which they are in violation of. Recommendation, based on the testimony and evidence presented in case number 2253 CESM, it is determined that the respondent is the record owner of the property located at 805 Francis Street, Altamont Springs in Seminole County, as determined by the property appraiser's records, in possession or control of the property, and in violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1. It is further recommended that the special magistrate order the respondent to correct the violation on or before August 12th, 2022. In order to correct the violation, the respondent shall obtain the required permit for the cited violation. If the respondent does not comply with the order, a fine of $50 will be imposed for each day the violation continues or is repeated after the compliance date. The respondent must contact the inspector to verify compliance. This concludes my presentation.
Thank you. Does the respondent wish to respond? And if so, state your name.
Melissa Borman.
Okay.
A lot of those things I never got, and the only letter to be certified that I signed was the one for today's hearing. I didn't hear anything since 2018 from this department. And as soon as I got the letter, I got 2 letters on Valentine's Day this year, and I came up immediately to try to understand what was going on. Of course, I don't understand, the fence has been there for 30 years. It was there when I bought the property. It was damaged in the hurricane in 2017. It's not a new fence. It's reset. I have the papers from the insurance company. When I bought the house, they didn't show me that there was a permit from it. But I'm retired, and it's going to cost me a lot of money, and I'm concerned about my safety because it's a corner lot on a busy street, and in the back of the house, my bedroom windows are like this far off the floor. They're sliding glass. And is there a way to hire a licensed contractor to come out and check it, get a permit, have him check it and make sure that it's in compliance, and then pay my fine and then come back?
Am I understanding correctly that the fence is in the setbacks? Did you say that, or did I misunderstand that?
That was the correction that was sent back.
Back in 2018?
Correct, that was never responded to, which is the reason that the permit was voided, because the correction was never responded to.
I never got anything about it.
I don't think there was ever, excuse me, my name's Jeff Acker. I don't think there was ever a permit, period. Do you have one that she signed? Because I came up trying to get a permit, and then you said that the owner has to do it as owner of record. So she came up a following day, tried to pull a permit, and for whatever reason, we couldn't do it at the time.
Correct,
that
there
in
was an
20
application for a
Okay.
permit.
That was an application.
That was in 2018?
Yes.
Okay.
Yes.
And I didn't hear anything except I got a photograph, but nothing saying I was in violation. And I didn't get anything until Valentine's Day this year. And that day I got 2 envelopes, one that looked like it had a certified sticker on it that was removed, and I hadn't signed it, and the other one, and they both had the same papers. And I was never notified that it's not where it should be until I came up to try to find out what to do, because it's all
Okay,
Pretty
let me
complicated.
ask the county just, do you have a copy of the notice of violation in the file? Or a certified mail receipt or an affidavit of posting? Just so that I know what happened with the initial notice? And then I understand the permit comments are separate.
Oh,
Okay, this one is for the notice of hearing, but that's in the packet, so we know we have that one.
This is for the,
That's for one of them,
that's for this one.
So I have a copy of the notice of violation that you're saying you didn't get, but I don't have a copy of certified mail yet, but maybe now I will?
This is her case file.
Okay. Is this the green
This is an
card?
affidavit showing that we sent this.
Okay, let me just
And
check
this
if
is the
that,
certified notice.
thank you. Oh, but this is for the hearing, today? 2022?
That's one of the letters that we sent, and then going back.
Yeah.
Um, 2018, I don't know if they actually copied the certified one, but
That's the issue. I'm trying to make sure, because she's saying she didn't get notice, I'm trying to determine if the notice of violation in 2018 was received by green card or posted on the property.
Not sure how they did it in 2018.
Yeah.
But the very next letter that she would have gotten been the one from February of 2022, so what did she say?
And that's the notice of hearing, not the notice of violation, right?
This is a final letter of the notice of violation.
Let me see that. Oh,
But she's right, she didn't hear anything from the beginning to the end because the permit was voided, and I believe they got a complaint, and that's how the
okay.
meeting started.
I understand. Thank you for explaining. So, I'm trying to find, so there's an affidavit of mailing of a notice of violation in February. And did that document state what the violation was?
Yes,
This February, yeah, I got 2 envelopes.
That's the one
same
from
thing.
Valentine's Day. Okay. Okay, so I'm just making sure that you got notices. You did. Now, the separate issue is you didn't know what was going on with your permit. Thank you, County.
Okay, but the first notices I got were on Valentine's Day this year.
Right.
And I wasn't notified that it wasn't where it's supposed to be until I came up here and they sent me to the planning department.
So,
And then that was like overwhelming, and I guess I've been waiting to have this meeting to decide.
yes. Well, we're glad you came today, and what I would suggest, if you go in the doors here to the first floor to that permitting, they can answer questions about the permit. What it sounds like to me, based on what the county is testifying to as your comments from 2018, is that your fence might be in the setback. And if that's the case, you'll have to go to the second floor to planning, because you would need to apply probably for a variance to keep it
I'm going
there.
to take the fence down before
If you
I
take
do
it down,
that.
then you'd be in compliance, and
But how do I know where the setback is?
And does it matter when the fence was built originally and put up there? Or, I mean, it was 30 years ago, so what rules or laws do we go by 30 years ago?
Yeah, I've lived there for 20 years, and I've never been notified that needed to be moved. And there's a lot of big pine trees that I would have to move it, and that's a lot of money.
do you want to respond to that question?
As you just stated, you replaced that section of fence in 2017?
No, not replaced.
We had a hurricane
Fixed it.
in 2017, and it was 2018 when you came up and
Yeah.
signed for the permit.
So
And it was...
fixing a fence is replacing a fence if you go over one panel of fencing. So you get one 8-foot panel of fencing or under that is just considered a repair and doesn't require a permit. Anything over that requires a permit.
Well-
So even if you were to use like the original posts and just put new paneling up, that is still considered a new fence and would require a permit.
My thing for my insurance company says detach and reset, and paid for the stuff to reset it where it was.
Correct. That
When
is
the
that is
hurricane
considered replacing the fence and requires a permit.
Okay, so you want me...
There's a couple of options. One is you can take down the fence, and I believe, I mean, I don't have a survey of your property, but there may be a way to put up a new fence that is not within the setbacks and get a permit in advance of doing that. You could talk to staff about that. But the other option would be to submit an application for a variance for the existing fence, and you'd have a hearing on that, and you would explain what you're explaining to us, and then if you get that variance, then you can apply for the permit.
Does that require the $600 that is non-refundable?
I do not know the fees.
Yes.
Do you know the fees?
Yes.
Yes.
They told, and it was non-refundable, and it didn't guarantee that the request would be granted.
No, because staff doesn't make the decision. It goes to a board. It goes to a board of adjustment. So staff takes the $600 to review the application, prepare the agenda, take it to the board, but the board makes the decision.
Now, my next question would be, if it's a see-through fence, there is no permit required, is that correct?
There is still a permit required, but again, you would need to speak to planning and development on the second floor to find out if there's a difference in the allowable setback on a see-through fence. It would still require a permit, but it may be allowed to be in the same place.
I was under the impression a chain link fence was not required if it's on the property line. Am I wrong?
The only time that a fence does not need a permit is if it is a fence on the exterior of a agriculturally zoned property, and that doesn't count if it's privacy fence.
Okay.
There may be additional options you can speak with planning about. Do you think that giving you a compliance date of August 12th is something that would work? I mean, if you plan on taking down the fence, then August 12th seems like it would work for you. If you plan on applying for a variance, you might need a little bit more time. So I don't know what your thought is on the August 12th date.
Is there no place to appeal this?
Well, I haven't issued an order yet, but there is a place to appeal this. Once I issue an order, you have 30 days to appeal to the circuit court, if you want to. I haven't ordered anything yet.
Well, I think what's being asked is unreasonable.
Okay, and what are you asking the county to do?
I'm asking them to honor my survey, my title insurance, the fact that the fence is in the same place it's been for 30 years, and just to honor that and not cost me thousands of dollars. It cost me thousands of dollars to put that up. I live on a busy street. It's not the greatest neighborhood. I live alone. I mean, it just seems mean, actually.
I think they're just enforcing the existing codes. Reason being, if you put up a fence that's not permitted, how is the county to ensure that it's put up correctly and safely so that in a storm it doesn't blow into your window, your neighbor's window, or somebody else? So I don't believe they're trying to be mean, but I certainly understand your perspective, and it sounds like you have options. So you can have...
Like I said, if I ask somebody who's licensed to come and check my fence out, which I guess if I could get a permit for that, then I could come back and they could say, and if it's not where it's supposed to be, then I could pay.
Yeah, all that would be through the permitting process. But all I'm saying is that if it is determined that it's within the setback, the current fence as it is, if it's in the setback, you may have to also obtain a variance, but staff would tell you that. I'm just giving you the practical information based on the comments we know you got in 2018.
My question is, does the setback change over the last 30 years? Do you know?
That would be a question for planning development when you go up to the second floor. They're in full control of all the setbacks and things like that.
So if it met the 30-year requirement, but since now the permit wasn't applied for in 2018, then it would have to meet today's requirement. Is that correct?
Correct. If it had changed and you put up a new fence, which is what that would be considered, then it would have to meet the setback of the time that it was applied for.
Okay.
And how would we know if it was changed?
You can talk with planning staff, second floor.
But I kind of meant before all this happened, how would we have known?
When you put up a fence, if you come in for a building permit before it's constructed,
Yeah.
they would tell you that you're in the setback and would not issue the permit at that time.
But if it changes in the course of while I'm living there, they're not going to send me a notice and say, hey, you need to move your fence because we're changing the
No,
setback requirements?
only if what staff described occurs, if the fence comes down and you replace it. But they don't make you take down a good fence if the code changes after you construct it
That's what I-
lawfully with a permit, lawful construction with a permit. So I don't know if you are thinking you can come into compliance by August 12th.
Oh,
Apply for a permit, see what could come up with, or take the fence down. Take the fence down, you're in compliance.
And the other option is if you come in and apply for a permit and you have issues that are determined between now and then, you can come back and ask for more time. And if staff sees that you're working towards it in good faith and actively pursuing coming into compliance, most likely they would agree to a time extension request that's reasonable.
Okay.
Okay. Anything further from the county? Anything further from respondents? So there'll be no fines, imposed today. You'll have until August 12th to come into compliance. If it's not in compliance as of that time, you'd get another notice of hearing and another chance to talk about this. But at that time, $50 a day could be imposed, or you could ask for more time. Okay? But you'll receive an order explaining that in the mail.
So I have to fill out the application for the fence before I submit it and pay the fee.
That is a staff question.
Correct. So when you leave through here, make a sharp left once you go through the second set of double doors. There'll be another set of double doors to your left. Go through those, and then on your left is the permitting desk. They'll be able to answer any and all of your questions about the actual permitting process.
Okay, thank you.
Thank you. Have a good
Thank you.
afternoon. Okay, the next case is 2258 CESM, Respondent Veramonte Homeowners Association. Good afternoon.
Kyle Kasich, Building Inspector. I have presented a copy of this presentation to the clerk and request it be entered into the record.
It's accepted. Thank you.
Case number 2258 CESM is for the property located at 1346 Bancroft Drive, Longwood, which is owned by Veramonte Homeowners Association, Incorporated. The violation charged is Seminole County Code, Chapter 40, Appendix A, Section 105.1. Description of the violation is light poles removed and replaced without the required permit. Case summary is as follows. The initial inspection was 6/15/18. Notice to respondent was 6/15/18. Compliance date was 3/7/22. Follow-up inspections as shown both on-site visit and via computer. Results of the re-inspections, the violations remain on the property. This screenshot from the property appraiser's website shows Veramonte Homeowners Association Incorporated is the record owner of the property. These are copies of the received certified return receipts for notice of this hearing. This is a photograph of the violation of the removal and replacement of the light poles taken 6/15/18. This is another photograph of the removal and replacement of light poles taken 6/15/18. This is another photograph of the violation, looks like where they were removed. This is the replaced light pole taken 1/14/22. Another of the replaced light poles taken 1/14/22. Another taken 2/17/22. Another photograph 3/17/22. And finally 6/8/22. This screen shows no permits applied for or issued to correct the violation. This shows a copy of Chapter 40 in which they are in violation of. Recommendation. Based on the testimony and evidence presented in case number 2258 CESM, it is determined that the respondent is the record owner of the property located at 1346 Bancroft Drive, Longwood, in Seminole County, as determined by the property appraiser's records, in possession or control of the property, and in violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1. It is further recommended that the special magistrate order the respondent to correct the violation on or before August 12th, 2022. In order to correct the violation, the respondent shall obtain the required permit for the cited violation. If the respondent does not comply with the order, a fine of $50 will be imposed for each day the violation continues or is repeated after compliance. The respondent must contact the inspector to verify compliance. This concludes my presentation.
Thank you. Does the respondent wish to respond?
Yes, please.
And can I ask who, your name, are you?
Yes, I'm Gina Holbrook, and I represent Verimonte. I'm the association manager with
Okay,
Premier.
thank you.
Thank you. To say this is a mess is putting it mildly. Back in 2018, the prior board president did work with the board of directors at the time to remove the MSBU that was in place by the developer that was taken care of. He asked to manage the project. He was an engineer. He no longer lives in the community and is not cooperative. And so we have a board now who's been introduced to a violation from 2018, which we had no knowledge of. I don't know where the original notice went in 2018 because the property 1346 doesn't exist. It's not a parcel on Seminole County, nor is it a common parcel in Verimonte. So I talked to Kyle right away, spoke to a couple people at Seminole County to find out what we needed to do to come in compliance. And basically, we have to pull a street lighting permit. So we reached out to a licensed electrician, which was not used originally, we found out. So it was an education for the board and the homeowners, and of course myself. And so we had an electrician communicate with Seminole County to make sure we knew exactly what we needed. He has since come out and gave us an initial proposal of about $25,000 to $30,000. We just got the bid in for $230,000. So obviously we're bidding it out with other electricians. We don't know, I've been speaking with Duke Energy and Seminole County for the MSBU to reactivate that potentially. So they're looking either using the existing poles that the prior president had installed, and the wiring from Duke is still on the ground, it's just not active. So we're trying to find out if we can use the wiring and the poles that are there, pull the permit that way, use the electrician, or do we want to go back to the MSBU, which potentially we'll have to remove the poles, rewiring, so it's a process. This is a small community of 48 homes. It's a gated community, private, so the cost for all of this will be shared amongst the owners. I do have to go through a special assessment process, which is a 30-day notice to the owners. I have to give them 30 days to communicate and comply, and then, of course, we would have to build a special assessment, giving them a reasonable amount of time to pay their portion. And with 48 homes, we're looking probably about $350,000 if we go Route 1. I don't know the cost yet from Duke. They're still getting all that together for us to install the poles. We have to remove the current poles that are there, so that would take some time as well. The board is aware that there is a violation. Permits were never pulled. There was a low voltage permit pulled. I understand from notes that I've been provided since then, as a sample. Light poles certainly aren't low voltage, and speaking with Kyle. And so that permit was applied and never really utilized for the association. That was the only permit we could find at that time. The two board members that were on the board at the time, based on the engineer and the reports and him managing the project, went forward and approved it because they felt like it was a cost savings for the association at the time. Understanding that he was going to manage a project, do proper permitting. Being an engineer, we assumed that he would do all of that. Unfortunately, here we are today, and he hasn't done any of that. And the board's left with basically correcting the matter, and this is kind of where we are. So we know we have to correct it. We were going to have Smithson, who I know has called and talked to the county on our behalf, but with a bid of $230,000 and potentially another 50 to 75 more cost for wiring, permitting, those kind of things. We do have to go out and get a couple more bids. Certainly, if you live in an HOA, you would want that as well. So that's kind of where I am right now, is getting the bids for the board. We will hold a meeting as soon as possible and get that process started for the special assessment and get that moving. We certainly can't comply within 60 days. Obviously, if we have materials and we have to remove the poles, we're going to need a little bit of time. So I'm hoping we can get all this resolved within 120 days and get everything taken care of.
Thank you. County, what is your response to the request for 120 days?
County's fine with 120?
Okay, so ordered.
Perfect. Thank you so much.
120 days will bring you to, is that September 8th? Am I, oh, June, July. Oh, it's October. October 13th.
Okay.
Okay?
Thank you very much.
We'll send an order in the mail.
Okay, excellent.
And is the address for the order 3112 Westlake Mary Boulevard?
That's my office address. We did receive the
Okay.
one that
Okay,
was
so
sent
that's where the
recently.
order will go?
Yes.
Okay, thank you.
Thank you very much.
Okay. The next case is 2152 CESM, respondent Mr. and Ms. Rushing.
2152. My name is Cheryl Rushing.
Good afternoon. We'll let the county go first, and then you'll have your chance to respond.
2152. Got it. Sorry about that. I don't know if I have a PowerPoint for her.
Is this all your completed ones?
I didn't print out a PowerPoint for this one.
Right here.
That's Rush, that's not the right one. It's Rushing.
2152?
What's up?
Castlewood Court.
I'm good with looking at the screen.
Okay. I didn't print this one out for some reason. I am so sorry.
Ma'am, all the information they'll be reading is up on these two screens. Yeah.
Correct.
You don't have to read it unless you just have to, technically, because I know.
Are you just admitting that there's a violation and that you're going to come into compliance? Because the reason they will present
I'm in
evidence...
compliance is what y'all were telling me earlier. Do you remember we talked before?
Yeah, but we have to talk at the hearing in the public by
Okay,
law.
all right, go ahead.
Okay, thank you. Go ahead, County.
Kyle Kasich, Building Inspector. I have presented a copy of this presentation to the clerk and request to be entered into the record.
It's accepted, thank you.
Oh, go back. Case number 2152 CESM is the property located at 2459 Castlewood Road, Maitland. The violation charged is, I apologize, this is owned, hold on, there's a mistake here. This is a totally different one.
Is this the wrong one?
No, this got messed up.
That's 2252.
Yeah, 21.
It's 2152. Should I not print it out? It's 2152.
Yeah, because.
This should be a lien hearing,
Yeah.
2152 CESM.
Correct.
Okay.
So the property owner is William and Cheryl Rushing at 2459 Castlewood Road, Maitland, Florida, 32751. Inspector Kyle Kasich. The violation charged is Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits.
And we already found a violation, correct?
Correct.
What was that date, please?
December 9th, 2021.
Okay, thank you.
An order was issued giving the respondents a compliance date of March 10th, 2022. An affidavit of non-compliance was filed by the inspector after re-inspection on March 14th, 2022. An affidavit of compliance was filed by the inspector after the permit was obtained on May 31st, 2022. Recommendation, based on the findings of fact issued on December 9th, 2021, the special magistrate issue an order reducing the fine to administrative costs totaling $590.42 and require these costs to be paid within 30 days or the fine will revert to the original amount of $4,200 and will constitute a lien on the property.
Thank you.
This concludes my presentation.
And I do recall that you and I and county staff had a brief discussion before the hearing where you indicated you might want to request a reduction of that fine.
Yes,
So this is your chance.
Okay, I would like to request a reduction. I thought that it was handled and taken care of, and I think I showed you the papers showing February 22nd that he had done it, and something happened to him. I brought my neighbor because we were both using him as a handyman, and neither one of us could get in touch with him for about 2 months. But he had come by my house on around February 22nd, had me sign and said, "Don't worry about it, I've got it handled, it's taken care of." I thought it was, and I had not heard from y'all until I found the notice in my yard the other day. And then I realized we finally got a hold of him just a few days ago, and we think, he told me he'd had COVID, and he's an older man, and we think maybe he didn't seem to know when I said something about March 10th, you were supposed to have done it, and he said, March 10th? He did know at the time, but I think he's been sick, something's happened. And we were not able to get a hold of him. And my neighbors here can attest to that. But that's what happened and why I thought I was in compliance.
Okay, and we appreciate that, and I think the county agrees with you that you are in compliance, at least as of May 31st, and they have waived all of the fines since back when you were not in compliance, so now they're asking for administrative costs, the money they put in to the case itself through staff time and resources. So are you able to pay the $590, or do you also want to reduce the administrative?
I would like to reduce the administrative if possible.
Okay, so let me ask the county's opinion on that before I make a decision.
Okay.
The county's fine with that.
Okay, and so
Wiping-
what, completely
the fine.
wiping it?
Correct.
Okay, ma'am, the county is willing to not charge you, so I will go ahead and issue that order.
Thank
So
you.
you're in compliance with no fines.
Thank you very much.
Thank you for coming.
I appreciate it.
Okay.
It's less than 700? Okay.
And I believe that was the last case with the respondent present, is that correct?
Correct.
Okay, so we will go back to the cases with no respondent as soon as I make a note on this one.
I didn't print out the complied ones.
Okay, the next case is 2247 CESM, respondent Mr. Newman.
Kyle Kasich, Building Inspector. I have presented a copy of this presentation to the clerk and request it be entered into the record.
It's accepted, thank you.
Case number 2247 CESM is for the property located at 5080 Cub Lake Drive, Apopka, which is owned by Michael Newman. The violation charged is Seminole County Code, Chapter 40, Appendix A, Section 105.1. Description of violation is installation of an ornamental fence with electric gate and lights without the required permits. Case summary is as follows. The initial inspection was 11/16/21. Notice to respondent was on 11/17/21. Compliance date was 1/28/22. Follow-up inspections as shown, both on-site visit and via computer. Results of re-inspections, the violations remain on property. This screenshot from the property appraiser's website shows Michael Newman is the record owner of the property. This is a copy of the received certified return receipt for notice of this hearing. This is a photograph of the violation taken 11/16/21. Another taken 11/16/21. And a photograph of the light from 11/16/21. This photo taken 2/11/22. Another of the fence taken 2/11/22. And finally, a photograph of the gate and opener taken 6/8/22, also the light. And a photograph of the fence taken 6/8/22. This screen shows an application was received on 6/1/22 to correct the access control portion of the violation. Permit application 22-9221. This application is currently under review and has not been issued as a permit. In order, the permits shown on the screen are for gas, a screen room, reinforced concrete columns, a swimming pool, and a chain link fence with 2 gates, thus not covering the other portions of the violation. This shows a copy of Chapter 40 in which they are in violation of. Recommendation, based on the testimony and evidence presented in case number 2247 CESM, it is determined that the respondent is the record owner of the property located at 5080 Cub Lake Drive, Apopka, in Seminole County, as determined by the property appraiser's records, in possession or control of the property, and in violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1. It is further recommended that the special magistrate order the respondent to correct the violations on or before August 12, 2022, In order to correct the violations, the respondent shall obtain the required permits for the cited violations. If the respondent does not comply with the order, a fine of $50 will be imposed for each day the violations continue or are repeated after compliance. The respondent must contact the inspector to verify compliance. This concludes my presentation.
Thank you. So ordered. The next case is 2252 CESM, Respondent Canastris and Andrews.
What was the number? 22.
2252.
Gotcha.
Kyle Kasich, Building Inspector. I have presented a copy of this presentation to the clerk and request it be entered into the record.
It is accepted. Thank you.
Case number 2252 CESM is for the property located at 3024 Canaanwood Court, Oviedo, which is owned by George and Sandra Canistras and Barbara F. Andrews. The violation charged is Seminole County Code, Chapter 40, Appendix A, Section 105.1. The description of the violation is construction of a retaining wall without the required permit. The case summary is as follows. The initial inspection was 12/20/21. Notice to respondent was on 12/27/21. Compliance date was 2/25/22. Follow-up inspections as shown both on-site visit and via computer. Results of the re-inspections, the violation remains on the property. This screenshot from the property appraiser's website shows George and Sandra Canistras and Barbara F. Andrews are the record owners of the property. This is a copy of the received certified return receipt for notice of this hearing. This is a photograph of the violation taken 12/20/21. Another photograph taken 12/20/21. Another photograph of the violation taken 2/11/22. And finally 3/7/22. 6/8/22. I apologize, that wasn't the final one. This screen shows no permits have been applied for or issued to correct the violation. In order that they are shown on screen, the first permit there is a roof over, the second is a voided re-roof, the third is a fire alarm system, and the rest don't apply to this. This shows a copy of Chapter 40 in which they are in violation of. Recommendation, based on the testimony and evidence presented in case number 2252 CESM, it is determined that the respondents are the record owners of the property located at 3024 Canaanwood Court, Oviedo, in Seminole County, as determined by the property appraiser's records, in possession or control of the property, and in violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1. It is further recommended that the special magistrate order the respondents to correct the violation on or before August 12, 2022. In order to correct the violation, the respondent shall obtain the required permit for the cited violation. If the respondents do not comply with the order, a fine of $50 will be imposed for each day the violation continues or is repeated after compliance. The respondent must contact the inspector to verify compliance. This concludes my presentation.
Thank you. So ordered. The next case is 2257 CESM, Respondent Jimenez.
Kyle Kasich, Building Inspector. I have presented a copy of this presentation to the clerk and request it be entered into the record.
It's accepted. Thank you.
Case number 2257 CESM is for the property located at 2805 Oronal Way, Apopka, which is owned by Jose Jimenez. The violation charged is Seminole County Code, Chapter 40, Appendix A, Section 105.1. Description of the violation is installation of a fence without the required permit. Case summary is as follows. The initial inspection was 10/6/21. Notice to respondent was 10/11/21. Compliance date was 3/7/22. Follow-up inspections as shown both on-site visit and via computer. Results of re-inspections, the violation remains on property. This screenshot from the property appraiser's website shows Jose Jimenez is the record owner of the property. This is a copy of the certified return receipt for notice of this hearing. This is a photograph of the violation taken 10/6/21. And the other side, 10/6/21, 2/18/22, 3/17/22, 6/8/22, and finally the other side, 6/8/22. This screen shows an application was received 3/18/22 to correct the violation, 224359. This application is currently under review and has not been issued as a permit due to corrections required by the zoning department. Copy of application and date applied for, plan tracking information in PC status pending zoning corrections as of 3/25/22. This shows a copy of Chapter 40 in which they are in violation of. Recommendation, based on the testimony and evidence presented in case number 2257 CESM, it is determined that the respondent is the record owner of the property located at 2805 Ornell Way, Apopka, in Seminole County, as determined by the property appraiser's records, in possession or control of the property, and in violation of Seminole County Code, Chapter 40, Appendix A, Section 105.1. It is further recommended that the special magistrate order the respondent to correct the violation on or before August 12th, 2022. In order to correct the violation, the respondent shall obtain the required permit for the cited violation. If the respondent does not comply with the order, a fine of $50 will be imposed for each day the violation continues or is repeated after compliance. The respondent must contact the inspector to verify compliance. This concludes my presentation.
Okay, so ordered. The next case is a lien case, 2155 CESM. Respondent, Mr. Salazar. And since we've already found the violation, I just need evidence as to whether it's in compliance now or not.
Correct. Case number 2155 CEM, Sergio R. Salazar at 3572 Jericho Drive. Inspector Kyle Kasich, violation, Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by the special magistrate on January 13th, 2022, and an order was issued giving the respondents a compliance date of April 14th, 2022. An affidavit of non-compliance was filed by the inspector after reinspection on April 15th, 2022. Recommendation, based on the findings of fact issued on January 13th, 2022, the special magistrate issue an order imposing a lien in the amount of $2,800 for 56 days of non-compliance from April 15th, 2022 through and including June 9th, 2022, and the fine shall continue accrue at $50 a day for each day the violation continues and is repeated after June 9th, 2022.
Is that the completion of your presentation?
Correct.
Okay, so ordered. Thank you. And the next case is 2201 CESM, respondent Dyer and Danya Investment Co.
Case number 2201 CESM, Dyer and Donna Investment Co. at 121 West Hillcrest Street, Altamont Springs. Inspector Kyle Kasich. Violation, Seminole County Code, Chapter 40, Appendix A, Section 105.1, construction without the required permits. This case was originally heard by the special magistrate on January 13th, 2022, and an order was issued giving the respondents a compliance date of March 11th, 2022. An affidavit of non-compliance was filed by the inspector after reinspection on March 14th, 2022. An affidavit of compliance was filed by the inspector after the permit was obtained on May 6th, 2022. Based on the findings of fact issued on December 9th, 2021, the special magistrate issue an order reducing the fine to the administrative costs totaling $706.67 and require this amount to be paid within 30 days, or the fine will revert to the original amount of $2,750 and will constitute a lien on the property. This concludes my presentation.
Thank you, so ordered. And I believe that was the last case to hear, is that correct?
I believe so.
Okay, let's see. I think I have to approve some minutes. Ah, thank you. Okay, so I will hereby approve the minutes of May 12th, 2022. Confirm the date of our next meeting is July 14th, 2022, and we are adjourned.